Hi, thanks so much for joining our webinar. My name is Jessie Peterson. I am the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Andrew Nissen, an Oregon construction lien law expert. Today's webinar topic is don't sign a release unless it says this one thing. So without further ado, I'd like to introduce the fabulous and terrific Andrew Nissen.
Hello, I am Andrew Nissen. I'm an attorney at Aldrich Goldstein here in Portland, Oregon. We specialize in construction law. We do a mix of payment claims, delay claims, and also construction defect claims as well. So our clients include GCs, subs, developers, and owners, both commercial owners and residential. So today, got a lot of slides, but I'm going to try to do more of an overview, and then if you want to look back at the presentation later on the SunRay site, that is fine. In general, we're going to go over one simple change you may consider making to your contract, and then we'll talk about securing lien rights and bond rights. I'll do an overview of lien and bond rules and exceptions. Give you some lien law traps to avoid because it is a pretty technical area, and then finally cover the right way, in my experience, to exchange a release for a check. So your construction contract, what I have up on the screen is a sample attorney fee provision. A lot of times if you're a GC and the owner came up with a contract, or even if you have a form contract that you prefer to use, they will include what's called a prevailing party attorney fee provision. And that means that if there's a lawsuit or an arbitration, the loser pays the winner's attorney fees. Without that provision, unless there is a statute, then you don't have the right automatically to collect your fees. So a lot of people think that's a great provision to have. I would say, as a general contractor, consider deleting that. The reason being that you have other ways to secure your attorney fees if there's a payment claim. And at the bottom of the slide there, I put you may have the right to recover your fees on a payment claim in instance of a lien claim, which we're going to talk about today. You may have the right to fees under a bond claim, or you may have the right to fees under what's called the Prompt Payment Act. Prompt Payment Act doesn't apply to every project, but it applies to many projects in Oregon. So those are ways to get your fees without having this prevailing party fee provision. The reason that I say consider deleting it is that after the project is over and then everybody has been paid, that clause is more likely to benefit the owner because they may pursue a defect claim with the idea that they can get their fees back instead of just trying to work it out informally. So really, my experience is that the attorney fee provision after the project is over, after you've been paid, it really just benefits the owner more. So consider striking that. A lot of design professionals are already doing that. Architects and engineers do not like those clauses for the same reasons. So something to think about. Let's move on to securing your lien rights. Basically, a construction lien is a security interest in the property that you're working on. So that's the land and what they call the improvement, the building or whatever it is that you're constructing on the land. If you do it right, that lien is going to attach to the property. It's going to become part of the property records, and it'll have priority over a lot of other types of debt. So if there's a mortgage on the property, you can get priority over that mortgage, even if it was pre-existing, as long as you check all of the boxes. The ultimate remedy for a lien claim is a forced judicial sale of the property. They actually go and sell it on the courthouse steps. Now, that rarely happens, but what it does give you, again, if you do it right, is a lot of leverage to ensure that you get paid. And for over 100 years, Oregon State and many other states have had a policy of ensuring that contractors that work on projects have a way to ensure that they get paid. And so that's kind of how the lien laws evolved. You should know that the lien laws are what's called strictly construed. So your notices and timing are critical in order to protect and preserve your lien rights. Once you have the lien, it's a little bit more liberal, but you've got to cross all your T's and dot all your I's in order to secure those rights in the first place. So ways to ensure that you will have the right to lien or to file a lien and do what's called perfecting the lien. Make sure you have to be on a private construction project. You can't lien government land. So for example, we had a case involving a hotel out at the airport, right? The airport land is owned by the government. You can't lien that. What you can lien is the owner's interest in the hotel. So that's something to be aware of. If you're working on a project that's on government land, you may still have a lien if it's a private construction project. That's where you want to make sure that you do all of your research ahead of time so that you're not stuck trying to figure out how to lien something when you're starting to run out of time. So private projects only. You need to be a contractor or supplier that provides labor, materials, equipment, or services that are actually incorporated into the improvement, into the building that you're working on. So if you're just manufacturing materials off-site, the project goes belly up and those materials never actually get incorporated into the project, you may not have lien rights. So you got to be doing construction work on the project. As a contractor, you need to be licensed, bonded, and insured. If you don't have your CCB license in order, you don't have lien rights. Now, there may be ways to restore your license retroactively if you do something like forget to file proof of insurance. But the best practice is to just make sure everything is current all the time. You don't have to worry about that. If you're never licensed, then you don't get lien rights. You also have to have a contract that meets Oregon CCB requirements. So that means it needs to be in writing if the value of the work is over $2,000. If you go to the OregonCCB.gov website, they will have like a sample contract that includes all the information that you need under the law, the basic party information, your CCB license number, scope of work, payment terms, and then of course some way to sign it or show that you have an agreement between each other. There are also what are called pre-lien notices. You have to send those before you start work, would be the CCB consumer notices. There's like a 3-pack of notices if you're working on a single family home. I'm sure you know what these are. And those need to be delivered to the owner along with the contract. If you're a subcontractor or a supplier on a project, then you have to provide the notice of right to lien to the owner within 8 days of starting work. So not necessarily the first day that you're on the job. The law actually protects you for 8 days prior to starting work. As we will cover later, if you're a subcontractor or a supplier, it's a good idea to provide a notice of right to lien on every project, even if you're not required to. And this is because it helps establish priority over the bank, what they call the mortgagee. So if you don't provide a notice of right to lien as a subcontractor to the bank, then your lien, even though it may have priority over the owner, it won't have priority over the lender necessarily. And they're the ones with the money. And so we've seen a few cases recently where people come to us after they've already filed a lien, even though they weren't required to file a notice or send a notice of right to lien early in the project. Because they didn't, then the lender is saying, look, I don't really care about your lien because I'm first in line. So you want to preserve that priority, know what a notice of right to lien is. If you're a sub, I would just make it a habit of sending it on every project. Securing your bond rights. So this would be for a public project. I'm going to go through this pretty quickly, but just know that, again, you can't lien public land. If you're on a public project, you will be required to have a bond. And so you need to know if you're on a federal project or a state project. There's something called the Federal Miller Act that protects first and second tier subs and suppliers and allows you to file a claim for payment if you're not getting paid on that project. There's something similar called a Little Miller Act in each state, and Oregon has one. It applies to contracts over $100,000. And again, as a sub or a supplier, it can protect your right to get paid. There are specific notice and timing requirements that I put in the presentation. So latest on Little Miller Act in Oregon, you need to provide that notice within 180 days of the last date you performed work or supplied material to the project. Liens and bonds, rules and exceptions. If you're working on a residential project, as I've already talked about, you need to provide the 3-pack of Oregon required notices. That needs to be provided on or before the date the contract is entered into. I've got the link to the oregon.gov/CCB website. If you search required notices, it will give you that little package. And that includes information notice to owner, about liens, consumer protection notice, and the notice of procedure. That goes into the Oregon construction defect statutes. But you've got to have that as part of your contract that helps protect you and the owner. If you're a sub or supplier, again, make sure you provide that notice of right to lien. And the very bottom of the slide, you'll see the best, easiest practice is to just send it on every job to preserve your priority over the mortgagee, which again, that refers to the lender. So you send it to the property owner, you send it to their bank, their lender of record, and then you're good. Once you file a lien, you don't have to worry about, well, did I send this notice or not on this project? You've just kind of already done it automatically. Something else to be aware of, very important. You have to file the lien within 75 days of when you stop providing labor, equipment, or materials to the project, or 75 days after completion of construction. There's, of course, because we're in the legal world, a complicated definition of completion of construction. It can mean 3 things, either substantial completion, it can mean an owner has posted a valid completion notice, or it can mean that the improvement, the project has been abandoned. But basically, if you're not getting paid after 30 days, you need to think about filing a lien on the project. It's many times people will come, on day 70 or 74, and sometimes, you can still file it, you can pull it off, but anytime you're right up to that 75-day deadline, you're just giving the owner, I think, an excuse to fight the lien rather than just pay it. If you have a good, timely, well-thought-out lien that's got the backup information that we'll talk about, then you're more likely to get, whoever's advising the owner to just say, look, just pay this thing and get the lien off the property, and you're good to go. If you're close to that 75-day deadline, it gives people kind of an incentive to fight over the particulars and the details, because like I said, lien law is very, very technical. So give your lien service plenty of time to file and protect yourself. The lien itself needs to contain the following: true statement of demand after just deducting all just credits and offsets. So that's basically how much is owed after deducting the credits and offsets. It needs to include the name of the property owner, or what's called the reputed owner, who you think owns the property. It needs to include the name of the person that employed you. So that may be the owner, or that may be the general contractor. Needs to include a description of the property. The address is not required, but if you know it, you should put it down. And then you can also get the legal description for the property. And the claim finally needs to be verified by oath of the person who has knowledge of the facts. So in the old days, attorneys sometimes would sign liens, but if they weren't actually on the project, I don't think that's a good idea. Sometimes the company president, whoever that person is, can sign it. if they have knowledge of the facts. If that's an office manager or a project manager, somebody else that has knowledge of the facts about the project, they can sign the lien. That's fine. The main thing is it just needs to be verified by somebody that actually knows about this project. Here's a sample true statement of demand, how we might do it. You put the contract price, you put the agreed change orders, you would put, sometimes if there's disputed or pending change orders, you add all that up, deduct payments made to date, and put a total amount due. What we have started doing more, just in response to lots of questions from owners and the tendency that some people have, like I said, to want to fight on the details, is we provide exhibits as well. And this is something that you would provide to your lien service, and hopefully you've been keeping track of all this stuff during the project. So I just got a couple different ways that the information can be shown. This would be like a supporting exhibit that would show, okay, here's the work we did, here's the breakdown for materials and labor on the left-hand side. And then on the right upper, it shows the amounts due for labor, materials, services, and equipment. It gives kind of a little breakdown right there of what is in that amount that's owed. And then it includes an invoice summary. Here are the 6 payment applications that we made, the amounts that were paid. And you can see payment application number 5 was short paid, payment application number 6, no payment. So that's another way to show whoever's reading this lien, here's what we're claiming and what is in this lien. After you file the lien claim, after it's recorded with the county, you have to send a notice of lien filing. In Oregon, needs to be sent within 20 days. And that's usually combined with what's called a notice of intent to foreclose. That means you intend to file a lawsuit over the lien. That notice of intent to foreclose needs to be sent 10 days before you file a foreclosure or lawsuit. Easiest thing to do is put them both in one letter and send that within 20 days of filing the lien. Then you can file the foreclosure lawsuit anytime, as long as 10 days have gone by, anytime after that, and you're covered. The lien foreclosure lawsuit itself needs to be filed within 120 days of the date of lien filing. So if you remember anything from this, just 75 days from the last date of work on the project or substantial completion, and then the foreclosure lawsuit 120 days after that. So that's when you actually file in state court. Bond rule basics. Again, bond rules are, they depend on if you're a federal or state project. It depends on if you are, what type of bond you're dealing with. Generally, if you're on a federal project, you have to give notice within 90 days and you have to file suit within 1 year. If you're on a state project, notice within 180 days, suit within 2 years. But again, check the particular bond that you're dealing with so that you know what the notice requirements are. One area that people don't often consider is CCB bond claims, another potential source of payment. If you're a contractor in Oregon, you have to post a bond between $10,000 and $75,000. As a subcontractor that's not getting paid, you may be able to make a claim on a GC's CCB required bond. So just know that that's something out there. We've done it where people are, the project is completely out of money. There's no other source of payment. And we've helped people be able to recover some money that way. Lien law traps to avoid here. I would avoid signing anything that waives your lien rights preemptively. So before you start work, don't waive your lien rights. There are contracts, especially out-of-state contracts, that purport to waive lien rights. It may be enforceable in Oregon, but I would say watch out for any clause like that. It's important to, the lien laws are there for a reason. If you're not getting paid, you should be able to use them. Non-segregable liens, that's the exhibits that I was showing you that break down kind of the amounts owed. That's why you want to include that kind of information in the lien if possible. That way the owner or the bank, whoever's looking at the lien, they have some idea of what's included in the lien. The lien notices, make sure you're sending the notice to the right parties. Hit that 20 days, within 20 days of filing the lien. Delivered to the property owner, and then again, the mortgagee, the bank, lender of record. I usually recommend sending a courtesy copy to the original contractor or the general contractor, if applicable. That helps to avoid surprises on the project, and they may need to bond around the lien anyway. So I think it's good to keep the GC in the loop. There are various requests for information that you might be sent after you send a notice that you have filed a lien. And it's important that you respond to them or make sure that your attorney or your lien service responds to them for you. There are pretty short timelines, so just know one type of request you have to respond within 15 days. Another type of request you only have 5 days. So somebody sends it on Thursday night and you get it Monday morning, you may have to respond that day. The responses aren't terribly technical, but it's just failing to respond, you may lose your right to attorney fees. And that's, like I said, it's a technical area, and the whole goal is to keep your attorney fee rights. We've already covered this, but just, again, be aware that you've got 75 days to file the lien. And like I said, if you're not getting paid after 30, you need to consider filing a lien. Kind of easier to take it back than if you're late, you're late. You can't really fix that. So, try to be thinking ahead of time. I would say at least a month ahead of when you need to be filing. Okay, wrapping up here. What is the right way to exchange a release for a check? From the owner's perspective, they want to know that work has been properly and timely completed for the price agreed, and they want to know that they're not going to pay twice for the same work. So sometimes owners are counseled to get these really broad releases every time they make a payment. As a GC or a sub, you want to get paid. You want to preserve potential claims to the extent possible. So you have this sort of battle between a really broad release that the owner might be seeking or that a GC might be seeking against a subcontractor, and a narrow release that is the type that we recommend, if possible, that is just limited to the extent of payment. So you'll see there are two types of lien releases. Some projects will have one form that has a conditional release on one side and unconditional on the other. Some projects will have multiple forms. So basically, a conditional release means it's conditioned on payment. So that's used before you actually get paid. And on the left-hand side, there's an example that says you acknowledge upon receipt by the undersigned of a check. So as soon as you get the check, then you're releasing whatever the rights are that are noted in the particular release. That's different from an unconditional release, which should be used after you've already been paid. And on the right-hand side, you'll see it says the undersigned acknowledges they've been paid and has received a progress payment in the sum of X dollars. So unconditional releases usually will have big block letters saying, this is effective even if you haven't been paid. So just be aware of that, which type of lien release you're signing in order to get your payment. On the left-hand side here, we've got a sample broad release, the type that I would say use caution. This is the type that an owner might be advised to try to get. And you'll see that on the bottom there, it says this release covers full payment for all work, conditions, and occurrences through the following date. I don't recommend signing through a particular date, especially with the language releasing any and all other claims known and unknown on the above referenced job. That makes it much harder to make a claim if you didn't know about it, but you've already waived the right? So payment number one, you've waived all of your rights, but as it turns out, in the first week of the job, you have a delay claim or something like that. But since you've already signed the release, the owner's going to say, well, it's too late to make that kind of a claim. So a sample on the right-hand side is a targeted release, I think would be better for the contractor, is you're releasing it just to the extent of the progress payment that you are receiving. And then at the bottom, there's some language: you expressly retain and do not waive rights or claims as to any of the following: pending modifications or changes, so that'd be like your change order log, changes that are in process, also disputed claims, unpaid retention, or remaining work. So if anything, you want to make your release to the extent of payment only. If you've got somebody on the other side that will not pay you, or their bank will not pay you unless it's releases claims through a certain date, then find a way to list what those pending claims are. So you can say, okay, that's fine, but the following items are not released: these pending change orders, this potential delay claim, and unpaid retention. A lot of times if a project starts to go bad, especially we'll see that on big commercial projects, everybody is marking up the releases, the owner is trying to change it, the GC is trying to change it. So you just have to be aware and review every month's release. Make sure there's no language that wasn't there the month before. That's kind of the best way to protect you. And then finally, pay attention to what's actually written on the check. We have seen some people include language such as payment in full for all work, or the person endorsing the check hereby waives any and all claims. That's kind of a little last minute trick. Most people don't do that, but just, I have seen it before, so just be aware of what the language is, not only in the release, but also on the check. And I think that is it. So let me know if you have any questions. Otherwise, it's good to be here, and thanks for coming.
Yeah. Well, first of all, thank you so much, Andrew. You really were not kidding. You had a lot of slides and you managed to condense it down really good for us. So thank you so much. That was a lot of information, a lot of really great information. We do have a question that came through. This has several parts to it, so bear with me. I'm going to read the whole thing to you. I am a subcontractor on a residential job, and my notice of right to lien was not signed for when it was attempted to be delivered. Do I still have lien rights? If the owner and the GC do not receive a copy of the notice when it was sent, what is the best practice moving forward?
In general, the notice of right to lien, I'm not aware of a requirement that it needs to be signed for and acknowledged. The focus is on whether it's been actually delivered. So if you've got proof that it was delivered, I would focus on that rather than someone, refusing to acknowledge receipt of it.
Okay. All right. And then what about exceptions if it was lost in the, in the mail system, the USPS system?
I don't think I've had that happen. I've definitely had to trace things via certified mail via the tracking numbers, but I'm not sure. I'd have to look into that particular example.
All right, perfect. All right, thank you. Another question that came through, why are there only 8 days to send a notice of right to lien for Oregon, while in other states there are longer periods of time to send their preliminary notices? And are there any loopholes that extend that deadline?
The notice of right to lien is in Oregon, it protects 8 days looking backwards. So if you start the project and you don't send the notice of right to lien for a couple weeks, go ahead and send it, but it only protects you for those 8 previous days. It's not like you have, unless you did all your work in that first week when you hadn't sent it, you haven't blown anything, but it only looks backwards for 8 days. So the point of it is, if you're a subcontractor on a project, the owner doesn't necessarily know who you are, right? And so this is another thing that goes back 50, 80 years. They're like, okay, I've seen the cider around, but I don't know who they are. Okay, well, I got a letter in the mail from them that says, hi, I'm the cider, and I've been working on your project for the last 8 days. Just so you know, I have the right to lien the project if you don't pay the GC and the GC doesn't pay me. That's the point.
Perfect.
Of that.
Yeah. Notifying all the correct participants on that job. And then another question that came through, In your presentation, you stated that if you receive a post-lien request for information, you only have 5 days to respond. Is that business days or calendar days?
That, as far as we know, is calendar days. Usually, if we get a last-minute request like that after we send a notice that a lien has been filed, and then we get one of those, it's Monday morning, the request is due today. If there's an attorney on the other side, a lot of times we'll call them and say, hey, we got your notice. Can you confirm that we have a couple of extra days to respond to that?
Okay.
But if not, if you can't get a hold of the person, then yeah, I treat it as 5 calendar days. And like I said, the response is fairly simple. It's just important to get it out there.
Okay. And then I think this might be the last question that's coming in. It says, what if I accidentally sign an unconditional release? Is there any recourse to fight it if they don't pay in full or the check bounces?
There are ways maybe around that. I mean, different legal doctrines you can use, such as, there was a mistake or a misunderstanding or some type of wrong, maybe. I mean, that would be kind of case-by-case basis. You have to figure out what happened and basically how to fix it. But yeah, general rule, don't sign the unconditional release. And I understand that, this is probably a situation that's current, but forward-looking, wait till you have the cash before signing the unconditional.
Okay. All right. I think that is all the questions that have come through. If anyone does think of a question that wasn't addressed, please feel free to reach out and we will be sure to answer any questions for you as soon as we can. All right. If you don't mind, go to the next slide for me, please. All right, here are some of SunRay's resources to help you stay organized, know your deadlines, secure your rights. So go ahead and scan that QR code to access these incredible resources. It will have deadline calculators on there, project information sheets, which are really wonderful at the start of your projects. It will help you and your team get the right information from the get-go of who's working for who and everybody upstream from you. So please take advantage of that. You can also see the state lien laws rule. Remember, each state has its own unique lien laws, deadlines, and documents that are required, so please check that out. So scan that QR code so you can access all of that. If you could go to the next slide for me, please. All right, if you don't mind, take a moment to give us a review on Google. We'd really appreciate it. It takes about a minute of your time, but it really helps us get some feedback on the webinar and helps to always make it to where we can improve it and get some more content out there for you of what you're looking for. And then the next slide, please. All right, and with that, that is all we have for you today. Thank you so much to everybody who was able to attend today. We hope to see you at our next webinar. Thank you again, Andrew. You really are wonderful. I hope everyone has a beautiful and sunny day. Thanks again.